What's up, guys? Brian Fellow Law Group PLLC here with your Florida Law Weekly Case Update. Got 5 cases for you, so let's get right to it. First case is Azzam versus Portilla. It's out of the third DCA. Has to do with civil contempt and how it's very, very, very important to include in the notice of hearing for a civil contempt matter in a family law case the specific language. You have to have notice opportunity to be heard, right, for due process. Well, there's specific language in the notice for contempt hearings that has to be in there, and it's that language that you can copy and paste it. It's in all caps. It basically says if if you fail to attend, you may be held in contempt and in a writ of bodily attachment may be issued for your arrest. Specific language. It also talks about how you have to say whether it's going to be recorded. I'm assuming for purposes of appeal. There's specific language. Will it be recorded? Yes or no? You have to include that. Otherwise, you could have the most beautiful, beautiful contempt hearing, like President Trump would say, right? The best contempt hearing ever. Nobody's ever seen anything better. But if you don't have that notice, if you don't have that language in your notice of hearing, it's going to get reversed. So make sure you include that. Next case is Cruz versus a DOR. This has to do with disability when a parent and when an obligor parent is receiving disability benefits, Social Security disability essentially, and the child gets a benefit, or doesn't have to be disability, basically any Social Security, but when it's on behalf of the parent obligor, but the child gets a benefit himself or herself. The way this is done is you include the child's benefit as income to the obligor, but then you reduce the obligor's child support obligation on a dollar for dollar basis by the amount of the payment that the child gets. So let's say the child is receiving payments at the mom's house, and the father is the obligor, and the father is the one who is attributable for the Social Security benefit. It's his Social Security benefit. That's why the child is getting it. The obligor gets a credit for the amounts that are for the child's portion of that, but it's included as income to the obligor when calculating the child support. Next case is Wells Fargo versus Allen. This is not a family law case. I just thought it was very interesting. And for those who try to get away with things, right? So basically, what happened in this case, a foreclosure case. And so somebody bought this property after a foreclosure sale, thinking that the lien was wiped out. So what happened was the bank, Wachovia, prior to Wells Fargo acquiring it, Wachovia recorded two mortgages. One was like a $50,000 HELOC essentially, and then the other one was like a major, larger mortgage, something for more like $300,000. But what they did was they recorded the mortgage for the HELOC for the smaller mortgage first, and then 1 minute later they recorded the mortgage for the larger, the larger loan. And so they did a foreclosure action against the prior, the prior seller, obligor, and they, in their foreclosure action, at first they included themselves as a defendant, as a junior lien holder, but then they dropped themselves as a defendant, but they were still listed as a defendant in the case caption, in the case style. So when, on the final judgment of divorce, I'm sorry, on the final judgment of foreclosure, the Wells Fargo itself is listed as both a plaintiff and a defendant. And the way the judgment reads is that all basically all junior liens of the defendants in this action are extinguished, right? Because that's how it goes in a foreclosure. If you foreclose the first priority mortgage, it extinguishes the remaining mortgages, and then they can just get a money judgment, but their mortgages go away typically, right? So now a third party buyer buys the property thinking that this big mortgage is already gone. That's $300,000, basically second mortgage is already extinguished. Well, turns out it was not. The banks sued to foreclose. The buyer won at the trial court level because trial court said, well, all the other liens are extinguished, right? Because the $50,000 HELOC was the first priority, and so all the rest of them are extinguished. Appellate court said no. The final judgment really only said only the defendants who are, only the liens of the defendants who are defendants to this action are extinguished. The rest are not. And because even though they were still listed as a party in the case style, they were actually dropped as a defendant. So they were not. Wells Fargo itself was not a defendant anymore, so their lien was not extinguished. So that's a tough one. So he takes takes the property subject to that large mortgage. That is unfortunate for him. Next case is Warner versus Warner. This one has a little bit of everything. This one has about imputed income. The guy was I think he was like an anesthesiologist nurse who apparently they make very good money. So he was on his own. He had his own practice as an anesthesiologist nurse, and he was making like $250,000 a year on his own. Well, during the divorce, he says, "I don't want to be working on my own anymore. It's not for me. Too much liability, whatever." So he goes and gets a job with a hospital, making about $100,000 a year less, making about 150. So the wife was saying, "Hey, he's underemployed. He's voluntarily underemployed. He had this great self-employment practice. He's making a lot more money. Please impute income to him." Trial court imputed income to him, averaging the amounts that he was making as his from his self-employment. That was error because there was no evidence of what his actual earnings could be going forward. Just because he earned it in the past, apparently, that doesn't mean that that's actual evidence of what he could earn going forward. So you need if something you're going to impute, you need evidence. You need to show the court this is what this person could make if he's voluntarily underemployed. Number one, step one. Number two, this is the amount that he could actually make based on some sort of evidence. I'm assuming from some sort of expert testimony or something along those lines. Any sort of evidence of that. There was none here. They just averaged what he used to make in the past, and you just can't do that. This was also reversed because the court, when calculating the wife's needs, the court included expenses that she was paying on behalf of the party's adult child living at home. So be careful with that. If there's expenses for the adult child, you got to take those out because you're not responsible as a parent to pay for anything for your adult child. So that shouldn't be counted for alimony purposes. This was also reversed because another one of those intentional misconduct by taking money out of your retirement account during divorce proceedings. Not so fast, my friend. Yeah, that's the football announcer. But basically, no, you can't. As long as they're using it for basically, marital bills, attorney's fees during the divorce proceedings, essentially anything other than a showing of a specific intentional misconduct. You have to show that if you're going to want to count something against somebody for either spending money in a bank account or taking money out of your 401k during the divorce, you got to show there's intentional misconduct. They can use it to pay for marital bills. They can use it to pay for their lawyer's fees during the divorce. So that was also reversed. Last case is Delgado versus Miller. This has to do with follow-up depositions. I love this one because this seems to happen in practice a lot. Let's say you take the deposition of a party of a former husband, spouse, whatever, and then maybe like a year goes by and you want to take their deposition again because the case hasn't settled and there's new information. Well, this case stands for the proposition is you don't have to file like you don't have to prove anything new as the person taking the deposition. You don't have to show good cause for like another deposition. There is nothing in the rules that says that. The onus is on the other side to file some sort of motion for protective order if they want to protect themselves from being deposed again. But they would be the ones that have to show good cause. They would have to be the ones to meet their burden. But there's no general rule or anything like that says you can't take a party's deposition twice. Take them again. Sure, why not? There's nothing that says otherwise. It's on the other side to file a motion for protective order and prove their case, why they shouldn't be deposed again. So just keep that in mind because I know a lot of times lawyers would just be like, on the phone or in an email, nasty email saying, you can't take my client's deposition again. He already took his deposition. Based on what? There's no rule that says that. So that got reversed. So they were allowed to take deposition again. All right, guys. Hope you enjoyed that. Hope everybody has a wonderful day and rest of their week, and we'll see you next time.